There was one case against Catholic University where the EEOC investigation lasted 2 years. There was 4 years of litigation. There was a week-long trial. It got appealed, right? And then eventually the DC Circuit said, nope, sorry, this is entangling. This is not something that can be brought. But that's 6 years of paying attorneys. So what EEOC does in this investigation stage can have a huge impact on these organizations. This process, even though it's not litigation, the same principles apply because it's the government inserting itself into these issues when that's something that should be barred by the First Amendment and something that shouldn't happen as well.
Welcome to the Napa Legal Podcast. I'm Frank DeVito, Senior Counsel and Director of Content at Napa Legal. You're listening to the Napa Legal Weekly Podcast, where we explore religious freedom from the perspective of faith-based nonprofit organizations. So for today's special episode, we're joined by our guest, Rachel Morrison. Rachel is a fellow at the Ethics and Public Policy Center, where she directs EPPC's Administrative State Accountability Project and shares office space with Napa Legal, so we know her well here. Prior to joining EPPC, Rachel was attorney advisor and special assistant to the general counsel at the Equal Employment Opportunity Commission, a commission that we're likely going to discuss a little bit on this episode, so that is relevant. She was focused there on religious discrimination issues. She also has experience as litigation counsel at Americans United for Life and as a constitutional law fellow at the Beckett Fund. She's a widely published legal analyst and, as I said, a good friend to the Napa Legal Institute. And Rachel, thanks for joining us. Happy to have you here today.
Thanks, Frank. It's great to be here.
So you came to our attention for this episode because there was an amicus brief filed recently. I believe at the time of recording, it was about a week or so ago, maybe a little more. And it was filed on your behalf supporting the granting of cert to the Supreme Court in a case called United States Conference of Catholic Bishops versus O'Connell, which I believe is colloquially referred to as the Peters-Pence case, which might make it more familiar to some of our listeners. The argument here hinges on whether denial of the USCCB's church autonomy claims can be appealed immediately or only after a final decision on the merits. So we're going to dive into that case and some of the issues surrounding these church autonomy claims. But I think I want to start with the kind of first and central question for today. What is the Church Autonomy Doctrine and why does it matter?
So the Church Autonomy Doctrine flows from the First Amendment. I think folks are probably familiar with the Free Exercise Clause and the Establishment Clause in the First Amendment. And so this is a principle that flows from both of those clauses, but is distinct from claims that are brought under one of those clauses solely. And so it's this idea that when it comes to churches, issues of doctrine, of faith, internal governance, these are things where secular bodies, the government cannot intrude. And so there needs to be this space for church autonomy to be making those important religious decisions. And so it flows both from the ability to exercise the religion, but then also this restraint on the government from intruding or imposing upon those important matters to a faith organization.
Yeah, it's a really important doctrine. And I think it's funny, we live in, especially in the last 80 years or so, a time where the separation of church and state is often weaponized as an ability for legislators and other government bodies to keep religion out of the public square. But from my work and my personal research, it really seems that the founding era, the suspicion was kind of the other way around. It was more an intention of making sure that the government was staying out of certain religious or church affairs. So I guess your articulation of the Church Autonomy Doctrine would kind of support that. That's the basis of this doctrine, right? Is making sure that there are certain spheres where the government is not allowed to interfere in the work and especially the internal governance and religious doctrinal questions of churches and religious orgs. Is that right?
Correct.
Now, I want to talk a little bit about the ministerial exception, because that's another important protection for religious organizations and also something that's made a lot of headlines with some recent cases. So how does the Church Autonomy Doctrine in general relate to the ministerial exception? How do the two doctrines play into each other?
So the ministerial exception is one aspect of church autonomy, but church autonomy is broader than just the ministerial exception. And for folks who might not be as familiar with the ministerial exception, this is a doctrine that the Supreme Court's recognized in a couple different cases that says that when it comes to key leaders at a religious organization, leaders that promote the faith, promote the mission of the organization, that it is up to the religious organization to make those determinations. And so the court can't step in. These cases arose in employment discrimination context. And so when you think about like what would the remedy of this case be if the former employee would have won, it would have been the government coming in and saying, religious organization, you need this minister or this other key employee to stay employed at your organization, or because you fired, improperly fired this employee, you're going to have to pay a lot of money, which would then give the perverse incentive that the religious organization would need to keep certain employees in key roles at their organization and have that be dictated from the government. And so you see that this is fits right in with the kind of the broader purposes of the Church Autonomy Doctrine, where it's this bar on the government coming in and trying to dictate some of these very important matters. In this case, who are some of these key players and employees at religious organizations and at churches?
Yeah, I mean, I think a listener wouldn't have to do much work to see how that would be a massive problem for, at the most obvious example, right? If a church is firing a priest or a minister, in the technical or in the religious sense of a minister, I suppose, and the minister has the ability to file suit and say you're violating non-discrimination laws or what have you, that's a huge intrusion of the government into the life of a church or a religious organization. So I want to turn to, you've mentioned this being a bar, right? The Church Autonomy Doctrine being a bar that keeps the government out of these certain religious questions or decisions being made by, well, we call it the Church Autonomy Doctrine, but it does apply beyond established churches to other religious organizations. So I think it's a little bit of a misnomer, but we can move on. But I guess there's a question about how exactly the Church Autonomy Doctrine functions legally. And so I guess I want to ask, what are the practical differences between the view of church autonomy as a defense from liability, right? Like there's a lawsuit and then the church or the religious org claims church autonomy as a defense, versus like a jurisdictional question where the church is immune from suit because it's outside the jurisdiction of the secular courts. Those are very different in principle. So if you could just talk a little bit about that and then also explain practically how that would make a difference.
Yes. So I do want to kind of affirm something that you said first before answering your question, is that the church autonomy, it's broader than just churches, right? It's also religious organizations or other faith groups that might not call their religious organization a church, right? The same thing with the ministerial exception, right? It kind of came about in a case that involved a minister, but it applies to employees that don't just have the title of minister, and also kind of other employees key employees at other religious organizations as well. And so we're using church autonomy and ministerial exception because these are like colloquially the names that have come up in some of the cases, but don't be misled by the name itself to thinking it's more narrow than it actually is, because it applies broadly to more faith groups and groups that don't have churches per se as well. So your question is kind of what are the current debates in this case? How did this come up? So in the Hosanna Tabor case, which is one of the ministerial exception cases at the Supreme Court, there was a footnote that said that the ministerial exception was an affirmative defense. It wasn't a jurisdictional bar. And so this went essentially to the ability of the court to adjudicate a claim, or whether the court would just have to throw it out of court immediately, not even answer the issue. And the court said, like, no, like in an employment discrimination case, this is something that the courts can look at. And so if an employment discrimination case is brought, then the religious organization can raise the ministerial exception or church autonomy as an affirmative defense to that claim. And so that's the world we're living in right now, is the affirmative defense world. But within this, and this is where the O'Connell case came up, is what does the affirmative defense mean in practice? Does this mean that it's a defense from liability only, or does it extend to broader? So think about if it's a defense from liability, that means that you just wouldn't have to pay the damages or reinstitute the employee or solve whatever remedy at the very end of the day. And you would still have to go through the entire process of the litigation, the discovery, the appeals, etc., before you get there. And so the other aspect, so some courts have said that's the case, and that's what the DC Circuit said in this case. But the other view, and what a number of religious scholars and what we're advocating for in our brief, is that it provides broader protection. It provides this protection from the litigation, like the process is part of this entanglement and part of this intrusion into religious matters when there is a valid church autonomy defense. And so this is a question before the court is, can this be resolved at the earliest stage to prevent this entanglement and intrusion of going through the entire process, or is it only something that can be determined at the end of the day? So that's one aspect of the question. And then kind of a related question, which is also at issue in this case, is whether a denial of the defense can be appealed immediately, or if you also have to go through the entire process to get a final judgment to appeal it. So normally you have to get a final judgment before you can appeal it. There's some exceptions to that. So in the case of qualified immunity, where you have a government employee, that's something that can be appealed immediately before you go through the entire process, because it's so fundamental to the case. And we argue that this is very fundamental, right? And so the process is part of that intrusion and entanglement, which violates the First Amendment. And so it's something that should be able to be determined immediately, to be appealed, to have that final decision on that aspect of it, instead of having to go through the entire process, which is time consuming. It creates a lot of financial strain. It's a distraction from a mission. And it creates some of these perverse incentives, especially for smaller organizations, minority religious groups that don't have the resources necessarily to fight a claim in court the whole way. It might be encouraged to settle or make certain key decisions in an effort to avoid these situations, which again is part of this like intrusion and influence from the government that the First Amendment is seeking to avoid.
Yeah, this is a fascinating one. I don't want to focus too much on it. We talked a little bit offline about the differences here, because from a philosophical perspective of what the law should be, I find it really interesting. And granted, the current state of the law is that church autonomy functions as an affirmative defense and not a jurisdictional bar. But I think it's really interesting because just from a gut reaction to it, to me, what the Church Autonomy Doctrine does is say that there are certain things that are not in the realm of secular courts. Obviously, this is very simplified, but to me, it smells a little bit like a subject matter jurisdiction issue, which our listeners know. Most of them have probably taken civil procedure and been to law school. And right, if a court lacks subject matter jurisdiction, then that's a case for early dismissal before the case goes forward, before you have discovery and all that. So yeah, Hosanna Tabor seems to make it clear that it was viewing church autonomy and the ministerial exception in that case as an affirmative defense, not as a jurisdictional bar. I think there are interesting potential developments. We had discussed this the other day, but that there's a concurrence from Judge Bumate in the Huntsman case in the Ninth Circuit in early 2025 that I think more than hints at the idea that church autonomy should be a jurisdictional bar. There's an interesting case for those who are interested in this question out of the Fifth Circuit. I believe it's called McRaney, that Judge Oldham wrote in the Fifth Circuit there, saying the same thing, that this seems to be more like a jurisdictional bar properly than an affirmative defense. And so I guess we'll kind of leave that there and get into some of the nitty-gritty of your case. But I think it's fascinating because I think philosophically there's a good case for it. I think practically there's a good argument and good reason to say that if secular courts don't belong in religious disputes, then saying that that's a jurisdictional bar and disposing of those from the outset is advantageous and maybe just for religious organizations. Clearly, that's not the law right now, but Hosanna Tabor was decided in 2012. The makeup of the Supreme Court looks a little different today. So I'm hopeful that we'll eventually get a circuit split on this issue where circuits will say affirmative defense, no jurisdictional bar, and this might be something that the Supreme Court takes up in the next couple of years. So I'm cautiously optimistic, but it's practically something I would love to see. Um,
Yeah, I think at the end of the day, whether it's jurisdictional or affirmative defense, as long as it can be appealed immediately and that question is decided at the outset before addressing kind of the merits of the underlying claim, like that's the most important kind of whether what you call it. And so, I mean, we're hopeful the court will take this case and maybe that will come up during the argument and something. I think some of what the footnote in Hosanna Tabor that said this, it didn't really like that wasn't kind of the main issue in the case. And so there wasn't a lot of elaboration, but I think a lot of courts feel bound to call it an affirmative defense, but then kind of how do we treat this affirmative defense? Is it like other affirmative defenses? Is it like qualified immunity? Like, is it something different? Because we do have the First Amendment constitutional considerations kind of on top of these other, kind of normal considerations that maybe other affirmative defenses, if it's like a statutory defense, right? Like don't have that same kind of consideration. So maybe it's, similar but different because of that. And so I do think it's definitely something that is developing and will be important for the Supreme Court to provide that clarity moving forward.
Yeah, no, it's a good point because you're right. If I take off my like nerdy pseudo scholar hat and I talk about like what's the practically important issue here, it's exactly what you said. If there's a denial of the affirmative defense of church autonomy, can we get it appealed right away? Because anybody who's been practicing law knows the burden of course, taking a case to trial, but even discovery to have to turn over potentially thousands and thousands of documents. Like, now, if this is a church autonomy claim, we want this disposed of before religious organizations have to go through this whole burdensome process, as you said earlier. So I think that's
and I think it's also important to mention that this is helpful for the plaintiff in the case or the employee or whoever's bringing this claim is they don't have to go through all the time and expense like on the merits just at the the 11th hour to then say just kidding, there's this affirmative defense, you don't win. And so it does promote judicial economy and it helps both sides of the equation, not just the religious organization as well.
That's a great point. You seem to be saying that clear laws help keep unnecessary lawsuits out of the courts. Yes, we're all for that at Napa Legal. So let's turn to this the Peters-Pence case and your argument in the amicus brief there. I know you were amicus or amica, I guess technically. Is that I guess we use amicus as gender masculine. Anyway, we don't need to talk Latin.
Amici, or
Yeah.
I guess that's plural. So it was on behalf of me and then my former boss at the EEOC, the general counsel, Sharon Fass-Gustafson. So it was on both of our behalfs. Yes.
Okay, very good. So the brief, it's interesting. The technical details are interesting. So your brief is focused on the EEOC, the Equal Employment Opportunity Commission. So how does this case impact EEOC investigations in general?
So the EEOC is the federal agency, the Equal Employment Opportunity Commission, tasked with preventing and remedying employment discrimination. And so it will investigate and potentially litigate charges of discrimination on the basis of race, color, religion, sex, national origin, age, fair pay, genetic information, disability. And so the commission can bring a charge of discrimination or an employee can bring a charge of discrimination. And so there's this initial investigation stage by the agency into these claims. It can ultimately result in litigation. It doesn't necessarily have to. But the same principles of church autonomy that apply during litigation also would apply during an investigation as far as what is the role of the federal government in requesting documents. The EEOC has subpoena power, right? Investigations can take years. There's pressure from the agency to conciliate, to settle the case, to do different things along the way, kind of before a formal finding of liability by a federal court. And so there's a lot of power this agency has to place, a time and money distraction burden on a religious organization kind of in the process. And so if there is a church autonomy issue and defense, and this is something that goes to, protected by the ministerial exception or some kind of other internal entangling church governments type issue, that shouldn't be, EOC should not be able to investigate that as well. But again, if this is the defense is something that, is just defense from liability at the end of the day, then that means that the investigations are okay. And something that we've seen is that the process is the punishment, right? There was one case against Catholic University where the EEOC investigation lasted 2 years. There was 4 years of litigation. There was a week-long trial. It got appealed, right? And then eventually the DC Circuit said, nope, sorry, this is entangling. This is not something that can be brought. But that's 6 years of paying attorneys. That's 6 years focus. That's a lot of time and expense on everyone's behalf. And so if the church autonomy protection had been determined at the outset, then it would have hopefully have avoided a lot of this time and expense and just hassle. And if you think about Catholic University, right, is a larger organization. They have more money and resources. They have, access to probably, good attorneys, other friends in the religious liberty space. A lot of other organizations are not in the same position. And so what EEOC does in this investigation stage can have a huge impact on these organizations and pressure them, either inadvertently or intentionally, right? It doesn't really matter if it has kind of the result of pressuring these organizations to give up some of their protections and their ability to make those important decisions for internal governments or who those key employees are at those organizations. And what we saw, what we wrote about is kind of like this process, even though it's not litigation, the same principles apply because it's the government inserting itself into these issues when that's something that should be barred by the First Amendment and something that shouldn't happen as well.
Now, I do want to dive into this particular case and what's going on here. But first, if I could go off script a little bit and ask, in general, you worked at the EEOC and dealt with religious discrimination. What are some of the more common EEOC investigation type issues that you would see involving religious organizations? How does this typically come up?
So an employee at a religious organization will often be fired, or a teacher won't have a contract renewed. And so they'll file a charge of discrimination alleging sex discrimination or national origin discrimination or religion discrimination, which is more clearly barred when it's a overtly religious organization. And so those ones are easier to dispose of. And so then the investigator will look at this. They'll start interviewing. They'll get a response from the religious organization. And if it's something they think might have some merit, then there's more tools in the tool belt to request additional information, payroll data, interview folks, kind of the whole gamut. So it's kind of like discovery in some ways, but during an investigation stage, not during litigation. And so so I think this is something that's really important and something that the EEOC's religion guidance, which is binding on the EEOC, but not binding on federal courts, or because EEOC doesn't have the substantive rulemaking authority kind of in this regard to issue those binding rules. But it states that this is an important issue that should be resolved at the threshold. And so kind of setting that marker is because we're talking about these constitutional restrictions on the government, we need to make sure we're not going beyond what is permitted by the Constitution. But again, that, this guidance came out while I was at the EEOC, but it isn't necessarily something that has, I think, always been promoted in practice. I think a lot of folks at the EEOC, they view themselves as helping the employee, the little guy against the big bad employer. And what some of them, I think, fail to recognize is that, these employers, even if they're larger, are the little guy against the big bad government who has infinite time, infinite resources, right? There is no kind of those external, economic type constraints on the federal government that there are on individuals and on businesses and organizations, because the federal government, you're right, these employees get salaries paid. Like there's nothing that's keeping them from or encouraging them to close these cases more quickly if they think that there is something that they can investigate. And so this is why this principle in this case, even though it's talking about litigation, would apply directly to the investigation stage, and having this consistent principle of like, where is this line and what is the role of the federal government would extend both to litigation and then also to the investigations as well by the EEOC, and then also other agencies that do conduct investigations. And I do want to say that just because a religious organization is a defendant doesn't mean church autonomy applies in every case, sure. Right? And so, but making that determination at the outset is the important thing, because if it does apply, then there needs to be that stop and not have that entangling aspects. And if it doesn't apply, then that provides the clarity moving forward where you can then go through the process. And I think that's really important.
Yeah. One more follow-up as a lawyer who's never litigated a federal employment discrimination case. So if the EEOC goes through its investigation at the end, they either find fault with the employer or don't, how does that impact? Because I assume you still maintain some right to litigate, even if you get a no discrimination ruling from EEOC. So how does that play out after the EEOC part is done?
So you're right. So for an employee to sue their employer for the employment discrimination, they first have to go to the EEOC. The EEOC can investigate. It can issue a notice of right to sue. So the employee just has to go to the EEOC first, and then they have the ability to sue in federal court. But concurrent with that, the EEOC is allowed to investigate, right? And they could investigate while an employee is suing as well. The EEOC could also bring litigation on their own behalf, and that doesn't inhibit the right of the employee to bring this case. And so you have kind of like the parallel tracks where the employee, as long as they go to the EEOC first, then they can sue in federal court. But the EEOC can also have the investigation. And sometimes some courts have held that just because you can investigate the aspects of the original charge of discrimination, but then if you think that there's kind of additional issues, you can go beyond kind of that original discrimination and have kind of this broader expansion of investigatory power on other, perceived issues or. And so like it's a very broad power, which is why that it's important. It's restrained when it needs to be. And so the EEOC can also litigate like that case against Catholic University, right? They were involved in the investigation and then also the litigation as well. And so it was kind of the 2-4 there for the EEOC.
Yeah, that's a really important practical point. As you said, especially if you're not a religious organization with the size and resources of a Catholic University of America, to have to respond to an EEOC investigation, potentially litigation coming from the EEOC, and then litigation from the employee. The process is certainly the punishment, no matter how it comes out at the end. So now I want to pivot a little bit and talk about this particular case, the USCCB versus O'Connell case. So can you give us just a brief overview of the facts and what's at play, like what's going on here?
Yeah, so there's the Peter Pence offering, right? And so this is an offering that like the Pope will then distribute to certain folks, and someone who attended heard a discussion of this case, gave an offering, and then was disgruntled about how this offering was allegedly used compared to what the person thought that it was going to be used for, and so sued in federal court. And so, I mean, this case seems to be very squarely within the realm of church autonomy. You're talking about like comments that were made from the pulpit, comments that were made from the USCCB, decisions of, from the Pope, like how are we going to use an offering, right? And so this seems very central to these issues of the church and kind of the internal governance, and I think it's helpful in these cases to think about like what would the remedy be, right? And so like what would the result be if the plaintiff wins? Would that be you can say X about Peter's Pence offering, right? Or you cannot, or or you have to say Y. Is that something the court should come in and say, like what you can or can't say about this? Or you can spend this money, you can give this money to help this group of people, but not that group of people. Or and I think when you think about it in those terms, it's clearly something that the federal courts and government should not be stepping into. And that's something that should be the realm of the church.
Yeah, that's a good point. It is reminiscent to me. There were different legal claims involved, but the Huntsman case in the Ninth Circuit early last year, where the disgruntled tithed individual who happened to be brother of John Huntsman, so it was a prominent case. But the argument was basically, well, I tithed, and the minister said that it was going to go to X but not Y, and I would have never tithed if I knew it was going to go to Y. And the majority in that, I think it was en banc, but the majority just said, well, there's no fraud or misrepresentation. They actually got to the case on the merits, but there was a really good concurrence in that case saying exactly what you said. Like, these are deeply religious questions. Like, what is a tithe? Does somebody have a duty to tithe as a Mormon in that case, whether the minister says it's going to go to X or Y? These are deeply religious questions, and it's inappropriate for the court to interfere and decide when it's appropriate for money from a tithe to go here or there. So anyway, point well taken. And this is an interesting issue. And these kind of fraud, misrepresentation, disgruntled giver kind of cases are coming up increasingly. So I think there's a good case for the Supreme Court taking this church autonomy issue up. So I guess my last main question is, why this case? Why your brief is supporting a grant of cert that would have the Supreme Court hear it. Why is this case in particular important for the Supreme Court to weigh in on?
I think this case clearly establishes or presents some of these circuit split issues on whether the Church Autonomy Doctrine is just a defense from liability, or also kind of the process itself kind of along the way. It also squarely presents whether the denial of a religious autonomy defense is something that can be appealed immediately or not, right? And that kind of ties into the first question of is it a defense from the process as well? Some of this goes to, I guess, maybe kind of like what would be the difference between, appealing it right away or just kind of a defense from liability, or a defense, kind of from the entire process as well. It's something like discovery. So if a church autonomy defense is raised, you'll probably have to have some type of discovery into that defense. But are you also doing discovery kind of on all the merit question issues at the same time, or is it bifurcated? And this is something that happens in a lot of cases. And so I think some of those practical decisions would come into play even kind of before you get to the opportunity to appeal a denial. And so they're very closely related. But not necessarily like the exact same question. It also raises a third issue on neutral principles, which is also another important issue. Is there are some instances like property disputes where the courts can come in and resolve those. If you have a contract, it's clear terms, right? It's neutral principles. You're not delving into how do you apply this, this aspect of doctrine, or, these religious statements, or, is this individual the person with the right authority under scripture, or whatever it is, right? And so you can resolve those cases with neutral principles of law that don't cause that entanglement. And so kind of how far does that neutral principles apply? Does it apply to other cases? What does it look like? And so it clearly presents, three important issues under church autonomy that there are circuit splits on, which is something that the court does look at. And I think just really important issues for the court to come in. And so I'm hopeful that the court is going to take the case, if not this case, hopefully another case, as you said, that these kind of disgruntled tithers are seems to be a theme that's starting to pop up. And I suspect that if the court doesn't step in here, that there'll be other cases, unfortunately, probably that'll present itself. And I think just kind of as a side note, just because the court can't decide these issues doesn't necessarily mean a religious entity acted properly, right? They might have discriminated against an employee for grounds that maybe we would think is, like morally not good or in other contexts might be unlawful. But there's some space for religious organizations, and I'm not implying that like that happened in this case or anything, but like there is some space for religious organizations to do some of these things that maybe we like or don't like, because the alternative is the government stepping in and making these decisions, and that's really important not to.
Yeah. Yeah, I think this one is the Peters Pence issue is kind of funny to me because I find it less compelling just from a practical matter than like the Mormon tithe one, only because Mormons, if I understand correctly, I'm a Catholic, so I may not, but I think they're pretty strongly like required or at least encouraged to tithe on their income. So if you're a Mormon and a member of the Church of Mormon, like you have to give 10% of your income to the church. And so I could see a little bit more legitimacy to being disgruntled about where the money's going. But I mean, it's Peter's Pence. If you don't like where the Pope is putting that money, like just restrict your gift and give to somewhere else. I don't know. I find, again, this is not a legal question, but just practically kind of silly to me.
Well, and then are the courts going to start coming, like if this case is okay, then like anyone who, becomes disgruntled with the church later or doesn't like how their funds were used are going to like come to court, and then the courts are going to be wading into like, well, what were the statements made? What did that actually mean? Yeah. Is this the appropriate use? You're like, was it those funds specifically, or was it someone else's, funds, right? And I think it's just like this is not the realm for the courts to wade into, and and I don't think most courts or judges want to actually be trying to wade into was that your funds you gave to Peters Pence that went to this thing, and like, is that what you thought? Is that what was said? Is that like they don't want to do that, and they shouldn't, and the Constitution prohibits them from doing that too, is what we're arguing.
Yeah, I think the practical floodgate of absurd questions that the court doesn't want to deal with and shouldn't deal with argument is a very good one. All right, is there, I guess, last question, because you do a lot of work on religious liberty, religious discrimination, a lot of the things that we're interested in at Napa Legal. So I'm happy and excited to watch whether cert is granted in this case, and we will certainly be on top of that. But is there anything else in the world of religion and law that you're working on that you'd like to kind of throw out before we close?
So for folks who might not be as familiar, a lot of our work with the Administrative State Accountability Project at EPBC focuses on federal executive actions and agency regulations. And so something we've been keeping an eye on are regulations that are proposed from different agencies, and kind of the religious liberty aspects, positive or negative. It was a lot more negative under the former administration, and we're hoping will be a lot more positive under this administration, and just kind of making sure that those concerns are raised and are addressed. And so that's something we're keeping an eye out on. Something else I think folks might be interested in is there was a Trump executive order on eradicating anti-Christian bias. And so we, my colleague Eric Niffen and I, also religious liberty attorney and a friend of Napa Legal, issued a report, like a response to that executive order on eradicating anti-Christian bias. And so we looked at the conscience rights and kind of the ability of religion to kind of how this is looked at in the rulemaking process. And then the last section was on EEOC, and some of the issues we talked about today with the EEOC were raised in that section, and how the EEOC has shown a disdain for religious liberty in various ways at times. And so that's something we're very proud of, and it was a compilation of, I think, years of our work and experience together, and something that we're hopeful that this administration and the Anti-Christian Bias Task Force will look at and try to take into consideration for practical ways to protect religious liberty. And even though the executive order was focused on anti-Christian bias, like our comments were essentially like anti-religious bias, and kind of protecting that broad scope of religious liberty and conscience rights for all people, because those rights aren't specific to one faith group, right? But apply across the board. And so that's something that's on our website. If you just Google eradicating anti-Christian bias, then it should pop up. But that's something I think folks might be interested in learning more about.
Yeah. That's great. I'm really appreciative of your work and Eric's work there, especially because at Napa Legal, when we're doing these religious liberty updates, we tend to be largely focused on either case law or legislation. And so the executive action and the administrative agencies, there's a lot of practical, implications of what they do or don't do for religious freedom. So thank you for your work. We're grateful for you all at EPPC. I think I quote Ryan Anderson about once a week in conversations.
Always a good choice.
Yeah, that's right. So we're so grateful for your work, and thank you for coming today and talking about this issue.
Thanks, Frank.
Yeah. So we will wrap this up. I'm grateful to Rachel, and I think we can link to your project in our show notes here on YouTube. And with that, we will just thank you to our listeners for joining us for this episode of the Napa Legal Podcast. As always, if you enjoy the content we're putting out, we appreciate it if you like the podcast, subscribe to our channel on YouTube or Spotify or wherever you happen to be listening from. If you want to know what we're up to at Napa Legal, or you want to support us, we always appreciate that. And you can check out what we are doing at napalegalinstitute.org. So we hope you'll join us next week as we continue to highlight and discuss some of the most important ongoing legal issues that affect religious liberty, and particularly the work of faith-based nonprofit organizations. We'll talk to you next week. Thank you, and God bless.